Hmm. Yun! Hello, hello, hello! Welcome, welcome. Ibi Hugalbot here once again for the third and final session of the final day of confirmation of charges hearing ni former President Rodrigo Roa Duterte at The Hague sa ICC. Meron ding review on his interim release dahil magwa 1 year na in March 11. So welcome, welcome. Paki-share na lang muna ang ating live na ito at paki-subscribe, like, and follow na rin sa aking mga social media accounts. Hello, hello. Paki-thumbsuck naman dyan. Sino mga nandito? Oh, yun. Yun. Lucaret is here. Maria Eliza Jansen. Right. Andito na naman. Aktong, baby. Rachel Tan. Hello. Tessie Labo from, puro tayo nasa YouTube, no? Oy, Windy City, Chicago. Hello, Jen. Celine Garcia. Wow. Kaano-ano kaya nito si Gob Gwen. Yan, 33068. Hello, Tisay Di Oro. Okay. Len OFWHK. Sir Ibi, asan ka? Ay, ang dali niyo namang mamiss si Kuya. Beatrice Prudente. Hi, Drama Babes. Hello. Okay, sino pa? Sino pa? Mary Old Lay. Annie May Di Amor. Nia. Jennifer Ferrari, watching from Switzerland. Oy, Switzerland. Wow, Jennifer Ferrari. Ang ganda naman. Kaano-ano mo si Enzo Ferrari. Glenn Flores. Hello, Annabel Angay. Maayong gabi kaninyong tanan. Good evening, good evening. Magandang gabi po. Crescenciano Prado. Julian's World 18, April 19, Abril 19 pala. Oh, ayan na, malapit na mag-umpisa. Adia Britan, Ronald Balan Valyada, Neri Kaduada, Jeremy Solid North, Nita Casel, sino pa? Ginred Tugonon. Parang Ingrid ata ito eh. Ginred Tugonon. Choco 123, Roy Maceda, Marchico Mandirigma. Nandito si Mandirigma. Ronnie Abrestante, Jim Lord is here. Wow, sa wakas, Jim Lord, nakabalik ka na rin. Kendra Bello, hello. Brian Pitogo from Yuka. Saan ka ba Pitogo? Pitogo, liluan mo na dong. Angel Galgo, yep. Cha St. John from Europe. Sana doon ka sa sa Western Europe. Malayo ka sa Eastern Europe na may giyera sa Ukraine. Lydia's Milestone Journey. Ralph Stephen Hontong. Watching from Katarman. Uy, silingan ha. SD Makayan, El Amboy. Oy, El Amboy, haven't seen you in a while. Ana De Rosa, nandito na naman. Thank you, thank you. Sheila Pai Balgos. Wow. Hear me out. Mandirigma. Oy, tapos na Mr. Number 1. Hello. Shout out. Taga-deliver ng maleta sa mga airport. Walang hiya ka. Putang ina mo. Nagdi-deliver ka pala ng maleta. Pero walang pera. Baka wag ka magtanim bala ha, Mr. Number 1. Iram Aknold from Hong Kong. Benjamin Abano. Hello, hello. Hi sir, tapok mi diriya tomorrow. Angel Galgo. Diriya where? Tanaw. Hi sir, tapok mi diriya. Saan kayo magtapok? Tomorrow, Angel. Nekfe Zachary. Hello, maayong gabi. Ving Bodyongan. Hello Sir Ibi. Tigon sa mo si Julie Hugalbo. Tagaliwan po siya. Kawork ko dati sa Cebu. Yes. Siya ay aking pamangkin, si Julie. Meron siyang kakambal. Kilala mo yung kambal niya at yung ate niya na si Joy? Yun, mga pamangkin ko yun. No? And Enra Alaiselef. Oy, grabe naman itong mga username ninyo. Megs Bella, Nia. Okay, Esperanza Lucena, Blueberry Rose. Oh, ganda. Oh. My favorite cheesecake, no? Blueberry cheesecake. Blueberry Rose, good evening. Anti-lovers. Anti-lovers? Why? Watching from South Korea. Anyong, bakit anti-lover ka? Richard Gores. Oy, boss, Richard. Classmate ko nung high school. Dante Apas from Yate. Hello, Dante. Nomhar from Zamboanga City. Oy, Nomhar. Taga doon yung asawa ko sa Recodo. Huwag mo sabihin ha. Nagla-live ako doon sa Recodo. Ang asawa ko taga doon eh. Nomhar. Okay, Juliet Simeon from Dubai. Manong Butog. Oh, ayan. Long time no see, Manong Butog. Lanay Eyes. Hello. Uy, Lanay Eyes. Wow. Broadman C. Heidi. Hello. Shout out ko na lang kayo muna. Hindi na ako magmomonolog para kasi mamaya hindi ko na mabanggit. Esperanza Lucena, nabanggit ko na to eh. Malvina Gemma Granada. Good evening, boss from Taiwan. Si Isaac Engalan. Rachel Tan is from Dubai. Zinette is from Bukidnon. No? Kilala ko yung mayor dyan sa Damulog, Bukidnon. Pag kung you're watching, Boss Mel Buro, Mayor Mel Buro of Damulog, Bukidnon. A good friend. Hindi na kami nagkita ilang taon na kasi doon sa COVID. Di pa ako nakapunta sa sa Damulog, Bukidnon. Hola from Barcelona, Evelyn Lapay. Hola. Arriba. Rose NV. Hello. Oy, Rose NV. Matagal din tayong hindi nagkita, Rose, no? Jovelyn Malina from Taiwan. Maria Madlao, Tagum City, Davao del Norte. Snipe R. Vivo. Eli Amboy. Oh, matagal na rin to si Eli, no? Hindi na tayo nakapag-live, no? Ving Bodyongan at si Brian is from Cebu City, and currently in the UK. All right. Okay. Annalyn Kalayag. I'd like to know kung taga saan po. From Nepal. Wow, from Nepal. Huh? Jim Lord, kanina may Iglesia ni Cristo announcement. Yes, no? They are condemning the persecution of the witnesses, no? Na instead na yung mga kurakot at ang mga akusado ang dapat pagtuunan ng pansin, ginigipit yung mga lumalabas na testigo in reference to probably, the Gutesa, si Kiko Barsaga, or si Leandro Reviste, at ang kasalukuyang in the hot seat ngayon ay yung ating Brave 18, no? Na mga former Marines at apat doon ay Army Reservist at Philippine Army. Yep. Tapok mi diri sa kwarto, sir, watching from Dubai. Uy, nagtapok pala sa kwarto, watching from Dubai, ha? Angel Galgo. All right. Huwag niyo akong pagtripan dyan sa kwarto niyo, ha, Angel, ha? Kung anong gagawin niyo. Baka anong gagawin niyo sa video ko. Ay, thank you. Sino ba to? Si Arlie. Ito pala si Arlie. Thank you. Liam Ezekiel, Jory B. Isa from Singapore. Amin Maninaw, Salvo Domaptar, Quiapo, Manila. Yes, Solid Duterte tayo, ma'am. Sesto from Estoril, from Carmona, Cavite. Zam Salazar is watching from Mandaluyong. Hello. Emma Di Castro from London. Galing ng mga taga-London, no? Glenn Oy, maayong gabi from Lapu-Lapu City. Hello, Glenn. Si Beatrice Prudente is watching from Pare. Jackie Noy is also watching from Hong Kong. Si Grace Pads from Kazakhstan. Gusto ko talaga makapunta dyan sa Kazakhstan, yung Central Asia, no? They're becoming the new tourism craze now, no? Yung Central Asia, Kazakhstan, Uzbekistan, Turkmenistan, Tajikistan. Sarap. Lady Devlin. Oy, ito yung pinsan kong gwapo na hindi na nagpapadala sa akin ng Nescafe Gold. Brad Raymond, good evening, Brad. Are you in Manila or in Cebu? Or are you in Switzerland? Angeli De Leos, present again. Hello. Joy Chuma Layson from Kalibo, Aklan. Ay, hindi puta. Mga Ilongga, gid na niya. Ilongga ba yung Aklan? Parang iba, no? Physical therapist from Alain, United Arab Emirates. Thinkster Kale is also here. Frederick Ople. Pa-shout out po ulit si Sara Duterte, ang aking presidente, of course. Ako si Ibi Hugalbot, taga Sugbo. Si Sara Duterte, ang presidente ko. Shout out yan, Frederick Ople. Kayo din, maggawa kayo ng inyong mga tributes to the Vice President. Simple lang, picture ni Inday, sabihin niyo yung pangalan mo, and then i-post niyo sa Facebook ko. Wag nang mahiya. Jerome Defensor, natural po ba si Ma'am Cathy Binag? Walang hiya ka naman, Jerome. Nangingintriga ka naman. Anong natural sabi mo? Hindi rito kada? Ewan ko ha. Pero nung nakita ko si Cathy, natural naman. Walang hiya ka talaga, Jerome. Good evening, sir, from Zinep. Oo. Maria Marisa Alisondra. Wow, nag-live kag otro. Live. Sabi ko nga sa inyo kanina di ba? Pangatlo to. Snow White Apple, hello from HK, taga Davao siya. Hi. LST Genia from Miami in Florida. The retirement state. Wow, Wilmy Perez Sevilla from the city of Maleta, Marikina. Putang ina, ang inyong congresswoman na si Stella, nag-deactivate na ng kanyang Facebook account. Okay. Nonchalant. Hello, Nonchalant. Manuel Cartagena. Anong kumusta si Pambari 4? Ewan ko, nasa Japan Ha? Kasama yung ultra old school dilawan na mayor ng Cebu na si Nestor Archibald na naging professor ko in engineering when I was taking engineering doon sa universidad dito. Hello, Sir AB, watching from Hong Kong. That's Ellen Subo. Malvin Gemma Granada is from Buntag, 3rd floor, and then Great. Oh yeah, I have to remind you, bukas nga pala, no, alas 8. We will be going live with Mike Defensor, bukas ng alas 8 ng umaga, and then by 12 noon, habang nagtatanghalian kayo, ay interviewin namin si Attorney Levito Baligod, yung lawyer ng 18 Marines. So abangan nyo yan bukas. I hope you can tune in sa dalawang live namin bukas with 3rd floor. Solid North, hello. Morakimo from Cyprus, hello. Manong Botog, andito na naman si Manong Botog. Sophie is from Banilad, Mandawi. Hi, Sophie. Oy, maraming salamat. Arlie Mars, karon pa kabalik, naglantaw sa UK. Hello. Oh, si Brad. Watching from the comfort of my coffee bar. Putang ina. Tutyal. Mga tutyal pala kayo dito. Pati yung ano ko, from my coffee bar. Wow, Brad. Padalhan mo na ako ng Nescafe Gold. Naubos na. Nasa coffee stick na lang ako ngayon. Walang budget. Lily McQueen Gamil watching from Sultan Kudarat. Wow. Sultan Kudarat, no? Sultan Kudarat. Wow. Mariam BC. Amping diha. Yes, Amping pod. Mariam. Thank you. Len Luri watching from Abu Dhabi. Nagsugod na daw. Let me see. Atong i-refresh. Wala pa man. Meron na. Wala pa naman . Yun, tama. Yun. Kakaumpisa lang. Okay. Ayan ang mga photang ina. Pumasok na sila.
Please be
Ah,
seated. Veuillez vous asseoir.
parang buhaghag na ang buhok ni Muto. Tingnan natin, baka nag-blow dry yan ng sandali. At ano ba yun?
Good afternoon, everyone, once again. Mr. Kaufman, you have the floor for 30 minutes for your final submissions. Please proceed.
Thank you, Madam President. Thank you, Your Honours. I don't propose to present a long rebuttal. The defence has made its submissions comprehensively, and it stands by everything that it has said and presented. I am, however, forced to respond just to a couple of the most egregious observations made by the learned prosecutor and the learned victim's representative. I will start with Mr. Nichols, the prosecutor, who tried to convince you that I had admitted that you cannot trust anything coming out of Mr. Duterte's mouth. Well, he took it completely out of context, didn't he? What I was saying, and what everybody understood, is that Mr. Duterte's speeches alone are totally insufficient to substantiate the charges against him. And the learned prosecutor apparently agrees. He said, throw them all out for the purpose of the confirmation.
Yun.
Even without the speeches, we have enough to confirm the charges. And then he celebrated the fact that he had managed to find one, and I stress, just one example of a direct order, so he thought, to kill, emanating from Mr. Duterte. And that is to be found in Incident 1. So, for the benefit of the record, let me just clarify and repeat what I said. And I refer you to transcript 4, page 65, at line 14 onwards. And I quote, P26, who, redacted, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told it was the mayor on the phone. Hyphen pure hearsay. That's what I said during the hearing. And I stand by my word that because I thought that maybe Mr. Nichols might have caught me out, I went back to the transcript and the record, and I looked long and hard, and once again, I quote P26's words from the evidence. I asked who called, and the redacted third party said, Superman. And to make things clear, the prosecutor's investigator then asked P26, was the person who took the call, was the redacted third party?
Shit. Teka. What the fuck? Teka lang. Yun.
Yes. So I repeat my submission with even more emphasis. Pure, unadulterated, and undiluted hearsay. Yes. So I repeat my submission with even more emphasis. Pure, unadulterated, and undiluted hearsay.
Putang ina. Hey!
By the prosecution is exonerating, they say I'm making a political speech and that my defense lacks substance. And when I devote more time than the prosecution and the victims together to legal arguments and challenging the evidence, they say I'm nitpicking. Well, fortunately, we have this honourable bench which appreciates the presumption of innocence and the need to examine the evidence thoroughly in order to examine whether the prosecution has proved its case to the required standard. We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand. Let me just screen you an example from the public record, from the public version of the pre-confirmation brief, so that the whole world can appreciate it. And the same goes for the redactions applied to the identities and roles of the various criminal cooperating participants. While I found this unfair and contrary to the spirit of transparency, which is meant to govern the conduct of the proceedings at this institution, I approached my counterpart in the prosecution and complained that the nature of his redactions would mean that most of my meaningful submissions, namely the attack on the evidence substantiating the 78 deaths, would require me to go into closed session. Don't worry, I was told by the learned prosecutor. We're going to release a lesser redacted version of our charging document and confirmation brief. Wonderful, I said to myself. But what in due course did we get? A document which merely released the names of the 8 so-called co-perpetrators and which caused a storm in the Philippines.
Right.
It even caused the Secretary of the Interior to state that his department had begun tracing the whereabouts of these so-called co-perpetrators. And in its lesser redacted version of the document containing the charges and pre-confirmation brief, the prosecution also released the names of certain high-profile victims which it had selected, thereby enabling it, and it alone, to talk freely in open session about certain incidents that it felt crucial to its case. From this, I submit, Your Honours, you can really appreciate the true inequality of arms facing the defence as it attempts to defend the client in the public eye, I stress in the public eye, at the International Criminal Court. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges, either obliquely or in closed session, including that hotly disputed incident with the CCTV. Well, we hope that we have found a way around that by referring Your Honours to the relevant places in the evidence, and we do trust you to pick up on the problems without the benefit of our full explanations in open session, even if the remaining part of our plea was rendered rather dry. But I do assure you, the general weaknesses that we have identified pervade throughout and are so recurring that the total value of the prosecution's evidentiary matrix drops not just below the substantial grounds threshold that the prosecution must meet, but hits the very rock-hard bottom. And I will summarize these weaknesses once more for the record. Layered hearsay, conjecture, over-reliance on accomplice evidence with offers of virtual immunity at the ICC, contradicting statements between participants in a crime, absolute lack of any linkage whatsoever to Mr. Rodrigo Duterte, and the total lack of support for an alleged crime, both in the documentary and forensic record. And regarding these documents, it is not enough to argue that the Duterte administration destroyed them. There is absolutely no evidence for that. It is an outrageously unsubstantiated accusation which is not alleged, and where the documentation does exist, the prosecution is quite happy to rely on it. But what is this threshold, this substantial grounds to believe threshold? Well, clearly, it is not beyond a reasonable doubt. That's the standard required for a conviction at trial. But it is considerably more than reasonable grounds to believe, which is the standard applied for the issuance of an arrest warrant. If I may, let us take the analogy introduced by Mr. Butuya, that boat of his that set sail in order to avoid leaving his victims stranded on an island. Your Honours, this boat is the confirmation process, and its captain is this honourable bench. We are all passengers in this boat. The favourable winds in the sea and in the sails are for the prosecution, the incriminating evidence, and the sharks and the rocks in shallow waters are the exonerating evidence, the hearsay, the contradictions, and the accomplice witnesses. I ask you to consider how many sharks and rocks that we have discovered and pointed out to you through our binoculars. Would you board that boat if you knew that there were substantial grounds to believe that the boat would sink if it encountered one of the aforementioned perils? Let me define the test using more strictly legal language. The evidentiary standard applicable, namely substantial grounds to believe, is met with respect to a discrete incident when, and I quote from paragraph 38 of the Said confirmation decision, there exists concrete and tangible proof demonstrating a clear line of reasoning underpinning the specific allegations. By way of parenthesis, I should state that this quote from the Said confirmation decision recognizes the fact that each pleaded incident in a document containing the charges must be proved to the requisite standard for it to be adduced at trial. And that is what we request the Honourable Pretrial Chamber to consider. I have been asked by the many journalists who literally mobbed me outside this court building whether I have been reporting on the proceedings to the former president. And I tell them, yes, of course, that's my duty as a lawyer. I have to report to my client. It would be unethical otherwise. And they ask me, what has he to say about the case? Well, I'm going to enlighten you all a bit. For the best part of a year, we have been litigating the issue of jurisdiction and fitness. Your Honours have delivered your rulings. However, even though you found him capable of standing trial, I permit myself to tell you just a little bit about what really goes on in prison. No more than a kilometre from here. I permit myself first to tell you about his reaction to the demand of the prosecution and the victims that he appear. I won't hide the fact that I thought it best for him to appear, not out of a need to satisfy the desire of the prosecutor, and the victims who desperately want him to face his accusers so that they can wave their collected finger at him despite the presumption of innocence. I did not want to disappoint his many supporters. That was my reasoning. His mini Duterte clones, as Mr. Butuyan derisively calls them, who have been deprived of seeing their former and beloved president for more than a year. I told him that Your Honours could have rejected his request to waive the right of attendance. We even had a barong specially fitted for him so that he would not have to suffer the humiliation of being put into an out-of-size blue suit, which would now dwarf his meager physical body. The same blue suit in that dreadful photograph, which still remains on the ICC website and that I would ask to be removed. But he took his decision, and as his counsel, I was obliged to respect it. And the day before yesterday, when Your Honours gave us a break, I went to that prison and I sat with him for an hour. I tried to engage him concerning the evidence, and he lost the desire to follow me within less than a minute. I offered to show him excerpts of the confirmation proceedings, a few minutes of the deputy prosecutor, a few moments of Ms. Massiter, and hoping that it might excite him a bit more, some of my own opening statement. He shook his head firmly. I implored him. I said, "Sir, look at what we are doing for you. We're doing our utmost to get you out of here." But once again, he politely declined. And I asked him why. I said to him, "Sir, don't you understand? They accuse you of murder. They say that you murdered thousands when you were the mayor and when you were ruling your country." And then he repeated the question that he has always asked me for a year or more. "How does the prosecution say that I did this?" "Well," I replied, "I thought until Monday that it was because of those speeches of yours. But then your prosecutor told the honorable judges the other day, throw them all out. They're not necessary for the confirmation. He claims that he still has enough evidence to convict you without all the bluster." And the former president repeated the question, "But how? I've never murdered anyone, and they talk about thousands." And then I tried to explain to him arcane concepts such as indirect co-perpetration. And then his eyes simply glazed over. And who can blame him? As I mentioned, it is the only highly technical means whereby the prosecution can artificially connect him to criminal activity, not of his own doing. I then tell him that the people who are incriminating him are self-confessed murderers, cooperating with the prosecution, whose names we can't mention in public. I tell him that in return for their dubious services and their expressions of so-called remorse, as the prosecutor puts it, they will not face trial at the ICC, probably nowhere in the world, and will be rehoused with new identities. Mr. Duterte, the ex-prosecutor, like me, can't understand the fairness of that, relying on not one, but a number of vicious criminals to convict him, when he remembers that he is supposed to be presumed innocent. I tell him the names of those criminal cooperating witnesses, because apart from us, he is the only person who is entitled to know. He tells me that he has not heard of any of them, apart from two, who he vaguely recalls from his days as mayor. Concerning one, from his days as mayor. Concerning one, his comment is liar. And concerning the other, scallywag. And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, "Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me." He then concluded, and pronounced as follows: I was a faithful servant of the people, and that is how I wish to be remembered. I have now accepted my fate, and I realize that I could die in prison. And on that somber note, my team and I realized that there was no point in continuing. So we tried to humor him. We told him that next month he will be 81. And we reminded him of the many people who visit Duterte Street and Duterte Park, the renamed locality just outside the ICC detention center, as referred to by the many, many pilgrims who have visited The Hague to feel closeness to his presence, even if they cannot witness his actual person with their own eyes. We remind him of the mountain of cards and greetings and of the forest of flowers that he received both at the detention center and at the court's premises on his 80th birthday. So many cards, all of which were read by his family, that we had to provide 2 sacks to take them back to our office. So many bouquets of flowers that the prison had to bring a van to take them away. The flowers that reached the court premises were strategically placed around the building, and although so appealing and desirable and coveted by the staff, were avoided once the staff was told of their origin. So these flowers just rotted in the corridors until the smell forced them to be thrown away. We showed him some photographs of his family. We showed him photographs of his youngest daughter, Veronica, Kitty, who writes to him every day so often that the letters are piling up in his room. His face starts to light up. We showed him pictures of civic events in the Philippines with Sebastian Baste and Paulo Pulong present. He laughed and told us what he remembers of their days as young men in Davao. We showed him pictures of Inday Sara greeting the enthusiastic crowds of people in the Philippines, and then finally his face beamed with pride. Your Honors, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one. Out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honors, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace in his humble dwelling in Davao. And with that, Your Honors, I conclude, and I wish to thank you for your patience and to thank the parties and the participants, and most importantly, my team, Dov Jacobs, Havnit Nikisetti, Sandrine Dusena, Davide Rancati, Alexandra Dezev Davi, Nicholas Russo, and Kaylin Chen, all of whom have worked throughout the last year for one cause alone, and that is to serve our client, Mr. Rodrigo Duterte, faithfully.
Merci beaucoup.
George Motok. Thank you very much, Mr. Kaufman. The chamber, my colleagues, and myself, we have the duty to recall certain issues. First of all, the reductions that you have mentioned now, it was already raised by the defense, and the chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public. Secondly, you talked about the health and capacity of the suspect. As you have clarified, this issue was already addressed by the chamber, and the defense must not make submissions on that point now because it is not appropriate. The decision is already available in the public domain. I thank you very much. And with that, we come to the end of the confirmation of charges hearings. I thank the parties. Did you want to the floor, Mr. Prosecutor?
For you, Your Honor. Yeah, thank you, Your Honor. I want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero weight whatsoever in your determinations. Thank you.
Thank you, Mr. Prosecutor. You want the floor again, Mr. Kaufman?
Madam President, but I do believe that the defense has the right to respond.
Wait,
Yes, says Judge Moto.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect, obviously, for your honors, but he has his arguments, which we shan't repeat here once again. They were all set out in a way, but that was not testimony, I assure you, Mr. Nichols.
merci.
Judge Moto, thank you very much. Now the bench will withdraw to deliberate, and we will render a decision on the confirmation of hearings within 60 days in accordance with the instruments, the provisions. We will come back to this court for a hearing on Mr. Duterte's detention. Court is suspended.
Mukhang nainis si Motok ah. Biglang tumayo, oh. Hindi pa nasarado yung ano niya. Tumayo na kaagad, oh. Walang iya. Okay. Suspended lang. Walang link eh. Walang link for no. So tapos na. Tapos na yung nasaan na ba yun? Okay. Closed session. Closed session. So yun. Tapos na yung what the fuck?
The past couple of years.
Teka lang ha. Teka lang. Hanapin ko. Baka may ibang link. Dapat may ibang link for the wala pa rin, no? Walang link. Walang link for the dito na lang muna tayo. Teka. Teka ha. Ito. Okay. Lipat tayo sa website. para ma-monitor natin. Okay, no? So tapos na ang confirmation hearings of confirmation of charges hearings. They have the court, the pretrial chamber has 60 days, no, as per the regulation, to render judgment whether to confirm the charges and proceed with the trial and transfer the case to the trial chamber, and or dismiss the case or not confirm the charges, essentially throwing out the case and effectively freeing Tatay Digong. Now, the issue of the question on jurisdiction is still with the appeals chamber, no? Kumbaga kasi tatlong chambers yan yung ICC, no, yung pre-trial chamber na parang piskalya nga to determine probable cause kung pwede mong maisampa yung kaso, at pag naisampa na doon na sa trial chamber, kung doon na yung formal na paglilitis, no, the proper trial. Pero mayroon ding pangatlong chamber, no, yung pinakamataas, no, sa dalawang chambers na yan, yung appeals chamber, kung saan pwedeng iresolba yung mga questions, no, of the decisions of both the pre-trial and the trial chambers. So ewan ko kung aantayin ba nila, because I think dapat ma-resolve muna nila yung question on jurisdiction, matudukan na, no, before ma-proceed sa trial, kung mag-proceed man sa trial. In fact, ang argument ko nga noon pa, and even Attorney Salpanelo also have the same view, na yung pre-trial chamber should have waited for the decision of the appeals chamber on the question of jurisdiction bago nila simulan itong pre-trial or confirmation of charges hearing. Kasi nga, halimbawa, magdi-decide yung appeals chamber, no, na wala nga jurisdiction ang ICC over Rodrigo Duterte. Paano na yung ginawa nila ngayon? Di ba? That's already moot. Kasi nga, rendered na walang jurisdiction. So dapat na-resolve na nila yan muna. But again, that's just me, no, and Attorney Sal and a few other lawyers. Pero yun, no, mahirap naman na may nakabinbin pang petition. Halimbawa nga dito sa atin, sa Supreme Court, okay. Halimbawa sa Supreme Court sa atin, no, may nakabinbin na petition, no. For example, let's just say a criminal case. Oh, ayan, bumalik na sila.
All rise. Veuillez vous lever.
Oh, ayan na. This is now for the
The International Criminal Court is now in session.
Yep.
L'audience de la Cour pénale internationale est ouverte.
Okay. This is now for the review on the interim.
Please be seated. Veuillez vous asseoir.
Is this the or rewind lang to?
Good afternoon to everyone. Once again, I welcome everyone, both inside and outside of the court. Court officer, please call the case.
Good afternoon, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121-0125. And for the record, we are in open session.
Judge Motok, thank you very much, Madam Court Officer. I will now ask the parties and participants to introduce themselves, starting with Mr. Prosecutor, Mr. Nichols. Can you please confirm to me the list of your collaborators that I received prior to the audience?
Yes, thank you, Your Honor. Same people.
Merci.
Judge Motok, thank you. Mr. Kaufman, once again, appearances for your team, the exact people present.
Madam President, it's the same people, but I would just like to mention Mr. Davide Rancati, because I butchered his name so often up until now that I feel I have an obligation to say it properly. Thank you.
Judge Muto, thank you. I will call on the legal representatives of victims to present or introduce themselves and confirm that the list is exact. Madam President, it is the same composition as during the confirmation of charges hearing. Thank you. To my left, there is Judge Adelaide Sophie Alapini Gansu. To my left, Maria del Socorro Flores Liera, and I am Julia Motoch, presiding judge. The hearing is held under Article 118, stating that a review of detention has to take place at least one time a year. The last one was on the 14th of March 2025. So the hearing will focus entirely on the detention of Mr. Duterte under 138 in the Rome Statute. I will also point out that an appeal by the defense against the last decision of the chamber relating to the defense of Mr. Duterte is still before the chamber, the appeals chamber. Consequently, the arguments and the responses must not be presented in this current hearing. I will give the floor now to the OTP for 20 minutes.
Your Honor, I'll be much less than 20 minutes, just a couple minutes. And first, I would like to apologize if I interrupted you in the last session. I apologize for that, and it won't happen again. Just very quickly, Your Honors, I won't even go through the law, Your Honors. We've been through this before, but there have been, we would say, no change in circumstances that would require the chamber, and it is under appeal to modify its decision. There has been a change in circumstances, I'll keep it very brief, Your Honors, which goes against granting interim release, which is the waiver that Mr. Duterte filed for the confirmation of charges hearing. In that waiver, he said, "I do not recognize the jurisdiction of the International Criminal Court." He said that he was forcibly pushed into a jet and renditioned to The Hague. He refers to his arrest as a kidnapping, none of which sounds as though those are the words of a person who would return voluntarily to the court. Mr. Kaufman had previously said in his pleadings, talking about if there was interim release to a third country, that Mr. Duterte would follow through video link. However, for this hearing, even though he's been granted a waiver, he also doesn't even want to follow from here. So that means if he was granted interim release and Your Honors had, as is within your power, ordered him to attend, it would have been very difficult to make that happen if he simply showed the same disrespect and did not wish to attend even through video link. That's all I have to say. Thank you.
Judge,
And I accept your apologies for interrupting me before. Nous pouvons maintenant...
Judge Motok, we will go to the observations of the legal representatives of victims. You have 15 minutes. Maitre Bakar.
Madam President, Your Honors, in behalf of the participating victims, we humbly submit that if there are recent developments that have an impact on this chamber's review of Mr. Duterte's detention, they are developments that strongly support and fully warrant Mr. Duterte's continued detention. Let me discuss these recent developments, Your Honor. The first one was cited by the honorable prosecutor, which is the reason for the waiver that was signed by Mr. Duterte. With his very clear declaration that he does not recognize the jurisdiction of this court and his insistent claim that he was kidnapped and illegally surrendered to this honorable court, Mr. Duterte has clearly demonstrated that he will abscond from the jurisdiction of this court if he is released from detention. Any condition the court will impose for his release will be considered by Mr. Duterte as non-binding, for the simple reason that he does not recognize this court's jurisdiction and that he is a victim of kidnapping. If Mr. Duterte cannot even hide his contempt for this honorable court while he is already under detention, imagine how Mr. Duterte will use this contempt for the court if he is released. Mr. Duterte has telegraphed his intention to escape from this honorable court's jurisdiction if he is released from detention. Consequently, Your Honors, he remains a flight risk if he is released from detention. The second recent development that is relevant on the issue at hand is the fact that more than 160,000 of Mr. Duterte's supporters submitted a letter petition to the Philippine Supreme Court urging the issuance of a writ of habeas corpus as a means to force the return of Mr. Duterte back to the Philippines. The Supreme Court case seeks to declare the arrest and surrender of Mr. Duterte to the ICC as void and unconstitutional. This show of support proves the stark reality that if Mr. Duterte is released from detention, there is a huge risk that his supporters will find ways and means to facilitate his surreptitious return to the Philippines in order to free him from this court's jurisdiction. The news source of this letter petition is the online news portal of Business Mirror, and the news article is entitled, quote, Duterte supporters rally at Supreme Court, present 160,000 plus signatures for quick resolution of habeas corpus petitions dated 23 February 2026. The third recent development relevant to the issue at hand is the fact that on 6 January 2026, 3 children of Mr. Duterte filed separate submissions urging the Philippine Supreme Court to issue a decision calling for the release of their father from detention. One Duterte son, Congressman Paulo Duterte, has insisted that the Philippine Supreme Court should declare that the arrest, detention, surrender, and extradition of Mr. Duterte are unconstitutional and violative of international law. Congressman Duterte has reiterated his request for the Philippines' highest court to issue an order in support of the release of his father and prohibiting the Philippine government from cooperating with the ICC. The news source about this action of Mr. Duterte's children is
Excuse me,
found
Counsel.
in the online news portal of...
Can the French booth please turn on the microphone? Thank you.
The news source about this action of Mr. Duterte's children is found in online news portal GMA News Online, and the news article is entitled, quote, Duterte kids tell S Supreme Court petition for father's ICC release not moot, unquote, dated 6 January 2026. We will forego arguing the statutory basis of our position and contentions, Your Honor. Thank you, Your Honor.
Judge Matak.
May I continue, Your Honor, because there was a misunderstanding on the...
Oui, vous pouvez continuer.
Yes, please proceed.
We further wish to point out, Your Honors, that the conditions set forth in Article 58, subparagraph 1 of the Rome Statute continue to be met, and there has been no change of circumstances within the meaning of Article 60, subparagraph 3 of the statute or Rule 118, subparagraph 2 of the Rules of Procedure and Evidence that would support and justify Mr. Duterte's release from detention. On the contrary, as we have shown earlier, the new developments support his continued detention. In fact, we wish to emphasize that the prior findings that supported Mr. Duterte's continued detention remain valid and undisturbed, particularly in light of the fact that the confirmation of charges hearing has been held. There are no new facts that have emerged that would undermine the legal or factual findings in this chamber's last decision on detention. There is absolutely no basis for modifying the earlier ruling. Your Honors, the purpose of periodic review under Article 60, subparagraph 3, is to assess whether the conditions under Article 58, subparagraph 1, as required by Article 60, subparagraph 2, continue to be satisfied. As the Appeals Chamber has made clear, this review is not limited to newly submitted material. Rather, it requires the Chamber to consider the totality of these current circumstances and to satisfy itself that continued detention remains necessary. In this case, the conditions under Article 58, subparagraph 1, A and B, remain firmly in place. We wish to emphasize that the Appeals Chamber has recently reiterated that pretrial chambers are authorized to assess the likelihood of future events. The question before this chamber is not whether interference is inevitable, but whether there exists a real possibility of such occurrences. On the present record, that possibility remains very strong. We wish to reiterate that there has been no material change in circumstances that support the entitlement of Mr. Duterte to an order releasing him from detention. On the contrary, the current procedural posture heightens the risk of non-appearance. As the proceedings advance, the suspect's incentive to flee increases. The end of the confirmation of charges hearing, which occurred today, further intensifies that risk as it brings the prospects of trial nearer on the horizon. Additionally, the conclusions of the panel of experts that Mr. Duterte is able to follow the proceedings underscore rather than diminish the risk. His capacity to understand and participate necessarily implies a capacity to assess his situation and act upon it, including the possibility of absconding. It must also be recalled that the Appeals Chamber has also found no error in the Chamber's previous determination that Mr. Duterte has demonstrated a propensity to interfere with investigations. That assessment remains unchallenged by any new evidence. No intervening developments have displaced it. Moreover, Your Honors, this chamber found and the appeal chamber affirmed that Mr. Duterte benefits from a network of supporters capable of facilitating his flight. The existence and nature of such a network are not circumstances that are easily altered. No information has been presented that would suggest this support structure has dissipated or disappeared. Consequently, the risk of flight remains very substantial. With respect to Article 60, subparagraph 4, the Chamber must consider whether the overall period of pretrial detention has become unreasonable, and if so, whether any delay is attributable to the prosecutor. Mr. Duterte has been detained since March 2025. However, given the gravity, the complexity, and the wide scope of the charges, the duration of detention is not unreasonable. Furthermore, there has been no inexcusable delay attributable to the prosecutor. The record does not support such an assertion. Finally, Your Honors, The position of victims and witnesses is a highly relevant and a significant consideration in this regard. The information provided to us by victims has always been consistent. They express genuine fears for their safety and that of their families should Mr. Duterte be released. The victims have articulated concerns about renewed instability and intimidation in their communities, particularly because of the holding of the confirmation of charges hearings. Therefore, we cannot stress enough the duty of the chamber to not only safeguard the rights of the suspect, but also to ensure the integrity of the proceedings and the protection of victims and witnesses. On the present record, releasing Mr. Duterte would create risks that the statute seeks expressly to prevent. Madam President, Your Honors, in light of the absence of any changes in circumstances that supports Mr. Duterte's release from detention, the continued existence of a significant risk of flight and interference, the advanced stage of the proceedings, the reasonable duration of detention to date, and the expressed concerns of victims, the participating victims respectfully submit that Mr. Duterte's continued pretrial detention remains both warranted and necessary. Thank you, Your Honors.
Judge Motok, thank you very much, counsel. We can now move on to submissions from the defense. Mr. Kaufman, you have until 1500, well, past. We've moved on.
Your Honours are aware, the defence has appealed the pretrial chamber's decision on the first detention review. That's number 357 in the case record. And since we are still awaiting a judgment of the appeals chamber, the defence will not oppose the continuation of Mr. Duterte's current detention. Thank you.
Judge Motok, thank you very much. Mr. Kaufman. So we're still speaking about 1500 hours. This concludes the hearing. The submissions will be taken into account when the chamber makes a decision regarding the continued detention of Mr. Duterte. That decision will be handed down within the deadline set within the rules of evidence and procedure. Once again, I thank the participants, the parties, interpreters, court reporters, and all other staff members who have helped run this hearing. The hearing is now adjourned.
Okay, so hindi nag-oppose, walang objection for the continuing detention. Ang ginawa ni Attorney Kaufman precisely because yung unang petition nila for interim release na dininay nga ng pretrial chamber is still subject to an appeal doon sa appeals chamber. Okay? So ibig sabihin, dapat ma-resolve na nila yan. Sana. So dalawa kasi. So two questions no ang nakabinbin ngayon diyan sa appeals chamber. The question on jurisdiction and then the question on the denial of the first petition or the only petition no for the interim release of former President Duterte. So again, it's a legal well not strategy but it follows no na bakit ka mag-object ng continuing detention meron ka pang petition and automatic naman yung deliberation niyan no ng pretrial chamber, so they will render a decision daw whether to continue or to grant the petition on the detention and grant the interim release of former President Duterte, which I doubt they will, no, considering the the bias that we have already seen. But going back to the arguments kanina, no, at yung mga ginagamit na mga palusot, no, nitong prosecution at nung counsel for victims, mukhang, alam mo, tagilid sila kasi, again, let's go back to the requirements of the case, no? Sabi nga natin, no, yung crimes against humanity, no, yung elements that should be present for it to be considered crimes against humanity, no, a systematic targeting of a civilian population that has to be defined, and in this case hindi na defined. Pangalawa, yung control of the accused based on the doctrine of indirect perpetration, which needs a concrete evidentiary requirement establishing the link, no, the causal link, na yung epekto, which is the killing, and yung implied order daw ay napunta doon sa mga perpetrators through the co-perpetrators, at dapat ma-establish nila na meron talaga, whether it's a verbal or it's a documentary in the form of a memo or a circular, which has been debunked and rebutted by the defense. So, sa tingin natin, wala talagang dapat rason, no? Kasi ang requirement nga, is sufficient grounds to believe. Iba yan sa reasonable grounds to believe. Reasonable grounds to believe, no, resulting in an investigation, mag-issue ka ng warrant. Okay? Substantial or sufficient ground to believe that the accused committed a crime, it's one notch higher. And it's just a notch below. Ano ba yung pinaka-ultimate na standard for crimes, for proving guilt, no, sa mga krimen, sa mga criminal offenses? They should be proven beyond reasonable doubt. Ang one notch lower lang ang substantial or sufficient evidence to believe that the accused committed such a crime. And the requirements for that is just a bit lower, a notch lower doon sa reasonable doubt. And as far as I'm concerned, as far as the defense is concerned, the prosecution and the counsel for victims failed to establish such a sufficient or substantial ground or reason or substantial ground to believe that indeed President Duterte committed such a crime. Maraming butas. Yung elements pa lang ng crimes against humanity, may butas na. Yung present nila ng mga 78 murders or 43 murders, 78 victims including the attempted murders, no? Marami no. But then again, nasa korte na, nasa pre-trial chamber na, and if they have prejudged the old man, then what can we do? It's up to the people now. So, antayin na lang natin at panonoorin natin ano yung mga komentaryo ng mainstream media, ng mga iba't ibang mga public intellectuals at mga legal experts patungkol dito sa fourth and last day of confirmation of charges hearing, pati na rin yung automatic review of the continuing detention of the former president. Again, please po, tomorrow we will be interviewing at 8 in the morning tomorrow. Me and Pam and Marlon of Third Floor Studios will be going live with Congressman Mike Defensor. We will talk about his involvement dito sa paglabas ng Marine 18, no? Itong Brave 18. Pag-usapan natin yan, kaming tatlo, at bisita natin si Congressman Mike Defensor. And by noon, tomorrow din, no, habang nagtatanghalian kayo, we will be interviewing the lawyer of the Brave 18 former military men who came out with this affidavit at doon na nga sa ombudsman ngayon na file na nila. So, dalawang interviews bukas, 8 with Mike Defensor and by 12 noon with Attorney Levy Baligod. Okay? So, ida-digest muna natin ito. We will review at we will look at clippings. We will look at, encourage ko kayo, basahin nyo yung sa mga quote cards doon sa Batas PH, doon sa GMA, doon sa yung mga mainstream media kasi madali silang ng mga quote cards eh. Kasi may mga researchers sila. Doon na lang natin muna babasahin at titingnan ano yung mga kanilang mga opinion. Anyway, thank you so much for staying with me. Maraming salamat sa mga nagpakulay at nagpadala ng kanilang suporta. Thank you. All right. I hope you have subscribed to my YouTube channel and have followed my other social media accounts. At sana po ay magkita-kita tayo bukas. Maraming salamat po sa inyong lahat. This is Ibi Hugalbot, the Amateur Pundit, live from Cebu. Thank you.